Our third paper is by Rodney Grunes, Emeritus Professor of Political Science from Centenary here in Shreveport, and he's going to be talking about kind of the companion to both of these acts, the 57 Act, which was about voting rights, and then the 64 Act, which was more about broader civil rights. But the Voting Rights Act of 65 really is the third major piece of legislation in this change.
And some would say the major piece of legislation, depending on the period.
Yeah. We'll let you two argue about that.
There you go. Okay. The 15th Amendment, the right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Now, given that the nation has been founded on the ideas of slavery and white supremacy, this came as sort of a radical departure. But notice it's not all that radical. It's a negative right, not an affirmation of the right to vote. Alan Lichtman, in his new book, The Embattled Vote in America from the Foundations to the Present, maintains that the failure of the framers to actually put the right to vote as a natural right and to leave it to the states, basically, was the fundamental error which continues today. The Voting Rights Act of 1965 was designed to fundamentally change this history of discrimination. And it is, certainly Johnson viewed this in part, as maybe the most important and successful empirically in terms of raising the number of people, the number of African Americans who have gotten elected. It's a tremendously successful piece of legislation, and maybe too successful, because it has produced an unbelievable backlash, especially by Republican leaders, who view this law as primarily benefiting African Americans and other Democratic voting constituencies. And that really is the thesis that I have. Well, by the 1890s, Southern states systematically acted to restrict the right to vote by African Americans, often following the holding of disenfranchising conventions. These states sought to ensure white Democratic Party supremacy through violence, through fraudulent elections, through statutory suffrage restrictions, through constitutional changes, and a variety of legal devices. Some of them were quite extraordinary, such as the grandfather clause and the white primary, which most of you probably are familiar with. And they would be eventually struck down by the Supreme Court as unconstitutional, but not until many years had passed since their enactment. And so the courts have that as a limitation. You can challenge things in court, and certainly the NAACP, Legal Defense Fund, started doing that in the 20th century to a large degree. But victory not only costs money, it costs time. When these things were, as we get into the 20th century, and these things are being struck down one after the other, the white primary, the grandfather clause, gets replaced by a white registrar with tremendous discretion. And indeed, it's the 57th Civil Rights Act that established the Civil Rights Commission, U.S. Civil Rights Commission. I studied under one of its members, and one of the reports he gave me had to do with the wonderful state of Louisiana, which had discretionary devices that you would find in the other southern states as well, including identification documents requiring two already registered voters, invariably white, to attest to the identity of a prospective black voter. try this one, asking blacks, but not whites, to provide their age in days, months, and years. I defy, you might try this out, see if you can do that. Sending blacks to the police station to register, rejecting applications that had a little mistake, underlining instead of circling, for example, failing to then to notify an African American prospective voter whether they have been successfully registered or not, and of course the odious constitutional interpretation text, which gave the most complete discretion. Well, Eisenhower did give us not only the 57 Civil Rights Act, the 1960 Civil Rights Act, but neither of them involved actually having the effect of registering voters. They were viewed as relatively weak but necessary enactments, but this was to change. And the change was really a response to what is known as Bloody Sunday, March 7th, 1965, when protests organized by the Southern Christian Leadership Conference, led by Dr. King, but he was not the marcher on March 7th, and the Student Nonviolent Coordinating Committee, SNCC, which had as its leader a very young 25-year-old by the name of John Lewis, who is obviously still a congressman around today. The Johnson administration had just gotten through the 1964 Civil Rights Act, and Johnson was not keen on going into the area of voting rights immediately. Plus, he had a Great Society program that he was concerned about, and so voting was sort of on the back burner, but not completely on the back burner, because he had directed his Attorney General Nicholas Katzenbach to start developing a Voting Rights Act, particularly after being lobbied by Dr. King. Johnson tried to prevent this march from taking place on the Edmund Pettus Bridge because he thought that if King went, there would be violence which could result in Dr. King's death. However, Hosea Williams, who was an aide of King, and John Lewis, they decided they would have a freedom march, and the whole nation watched in horror as Sheriff Jim Clark clubbed the demonstrators, in fact cracking the skull of John Lewis. And this was, the beatings were seen by 48 million Americans. The station was showing Judgment at Nuremberg. They interrupted the movie, and the nation got to see what was a horrific act. And 4 days later, the nation was shocked again when a Unitarian minister, the Reverend James Reed, was attacked outside of a white supremacist restaurant, and he died. And this then became almost a second triggering device. President Johnson delivered what some biographers of his have called his greatest speech, a 45-minute address interrupted by applause 36 times, seen by 70 million Americans, and he promised to submit in 2 days a Voting Rights Act. And he framed it, I think part of his genius was how he framed this, not so much as a political issue, but as a moral issue. He said, quote, "There is no Negro problem, there is no Southern problem or Northern problem, there is only an American problem." And then he ended his speech with the words of Dr. King, promising the nation that we shall overcome. Well, the march eventually did take place, by the way, helped by Judge Frank Johnson, one of the most famous and threatened judges in the South. And so, indeed, there was legislation, and it was adopted by extraordinary majorities. In the House, Congressman Emanuel Seller of New York began hearings, and in the Senate, we had both Hubert Humphrey and, very importantly, Everett McKinley Dirksen, the Republican leader, so you had bipartisan support. And so it was passed in the House by 333 to 85, 73 to 19 in the Senate. There was no filibuster. Went to a conference committee and was adopted by overwhelming majorities, and so the law became, on August 6, 1965, the law of the land. It has, I suspect, two types of major provisions, either permanent ones that last forever, and temporary ones that need reauthorization every few years. Sections 2 and 3 fell into the first category. Section 2 outlaws all election procedures that result in the denial or abridgment of any citizen of the United States to vote on account of race or color, and Section 3, known as the bail-in provision, authorizes the Attorney General to enforce Section 2, including requiring preclearance whenever voting discrimination is found. But it is in the temporary provisions, if you will, that the law would become the most controversial. Section 4 was the coverage formula, and it required a so-called triggering device. That is, if the area had less than 50% of eligible voters had registered or cast ballots in the 1964 presidential election, they were now covered. As a result, all elections held in South Carolina, Georgia, Alabama, Louisiana, Mississippi, 26 counties in North Carolina, and small portions of Arizona, Hawaii, Idaho were subject to the law. Section specifically suspends literacy tests, education or knowledge requirements requiring proof of good moral character, identification, vouching, and all other procedures that are enacted or maintained for discriminatory purposes. Then came the most controversial provision of all, Section 5, the so-called preclearance requirement. All future electoral changes of a covered jurisdiction had to be submitted either to the Attorney General of the United States or to the U.S. District Court in the District of Columbia. And so these sections did more than just outlaw literacy tests or other devices. It charged the national government with preventing future discriminatory actions by the covered jurisdictions and bypass state and federal courts, still dominated by segregationist judges. Well, this too was challenged in the courts, and a near unanimous court in South Carolina versus Katzenbach upheld it. Section 5 was upheld in Allen versus the State Board of Education. And so we had the Voting Rights Act of 1965. Well, within the first 2 years after adoption, the aftermath and consequences were amazing. Voter registration in the covered jurisdiction surged. Mississippi saw the most dramatic change, for example, as African American registration went from 7% to 60%. 30 years after the VRA, African American registration in the South had increased throughout the South to 73%. And the Justice Department and federal courts prevented more than 3,000 voting changes from taking place under the preclearance provision of Section 5. Well, the initial act required reauthorization of Sections 4 and 5, for example, and so it was reauthorized in 1970, again in 1975, then it went to 7 years in 1982, and for the fourth time it was reauthorized in 2006. And President Bush signed it, and so it still had bipartisan support and huge majorities in both the House and the Senate, even though there were amendments, and there was some evidence now of that voting rights no longer was voting rights in 1965. So 2006, we have the last reauthorization. The House approved it, and the Senate approved it, and so we have what was hoped to be something permanent, but alas, the law profoundly changed American politics, as Ari Berman points out in his book, Give Us the Ballot. The South flipped from Democrat to Republican. Minority voters emerged as a major electoral force, and Congress and the presidency shifted as a result. Plus, there was an ideological debate which even made its way into academia, particularly with the work of Abigail Thernstrom, who viewed this book as a kind of guaranteed proportional representation, particularly as the law began to be interpreted in terms of meaningful votes and preventing vote dilution. And of course, from some of the Democratic side, you could see this in minority and majority districts. And those were the basis of Thernstrom's argument. It produced a major counter-revolution. A prophetic comment. Georgia Congressman Lynn Westmoreland said, after his preclearance amendment to the 2006 reauthorization was defeated, he said, "We needed 218 votes in the House, but we only need 5 votes on the Supreme Court." And that proved to be prophetic. We knew that sections 4 and 5 were in danger in 2009 in the case Northwest Austin Municipal District versus Holder, where Chief Justice Roberts began to provide indication in dicta comments that past success alone, he said, is not adequate justification to retain the preclearance requirements of the Voting Rights Act, and that there were burdens being placed on the principles of equal sovereignty and federalism that had to be justified by current needs. These warnings became the basis of a landmark 2013 decision, Shelby County versus Holder. Although the Alabama county challenged the constitutionality of both the coverage formula of Section 4 and the preclearance provision of Section 5, the court limited its decision to finding the triggering formula to be unconstitutional. Chief Justice Roberts, in his 5-4 decision, conceded that the Voting Rights Act had helped to successfully eliminate discriminatory voting tests and abolish disparities in voter registration. However, both the coverage formula and the preclearance restrictions remained unchanged, he said, for more than 40 years, relying on old and outdated data. These extraordinary and unprecedented features, though rationally related to the problems identified in 1965, he said, were no longer appropriate given the principles of equal sovereignty as guaranteed in Article 4 of the Constitution and federalism embodied in the 10th Amendment. Our country has changed, he said, and while any racial discrimination in voting is too much, Congress must ensure that legislation that passes to remedy the problem speaks to current conditions. Now, I should tell you that there were thousands of pages of testimony in the hearings that the House and the Senate conducted. And all sorts of new data, particularly the number of cases that the Justice Department had to handle under preclearance to prevent voting discrimination, they were sort of ignored. And one of the more amusing comments was in oral arguments by Justice Scalia who said, well, don't be fooled by those large majority votes in the House and the Senate, because these people are just forced to do so by the perpetuation of the actions of the civil rights groups. Now imagine if they had been closer votes in the House and the Senate. What would he have said? He would have said, well, it no longer has the support of the American people, so it was a lose-lose situation. And even before the Shelby decision, the court in 2008 decided Crawford versus the Marion County Election Board and basically upheld one of the real central parts of the voting suppression movement, and that is by upholding voter IDs. For middle-class people, this isn't a big thing. For poorer people, for Democrats, for African Americans, for other minorities, it is a big deal. Well, all of the voting suppression type of movement increased after the election of Barack Obama and after the Shelby decision. And in addition to new and stricter voter identification laws, several of them have been found by the lower courts to discriminate against African Americans. By doing away with Section 4, it made Section 5, the preclearance, there's no longer any preclearance necessary because there's no longer a triggering device or covered areas. And so we see a whole movement adding to the voter ID laws, cutting back on early voting, curtailing same-day registration, closing of polling places in minority neighborhoods, attempted racially discriminatory redistricting, and the souls to the polls, the Sunday voting, eliminating online voting registration, making it more difficult for ex-felons to vote, and a campaign to purge voters from registration laws. And indeed, just this year, the Supreme Court upheld the purging of voters who who did not send back a postcard that was mailed to them telling them that if they did not reaffirm their address, and this was in Husted versus the 8th Philip Randall Institute, another 5-4 decision. And while these laws may appear to be racially neutral on their face, scholars have found that many have had a disproportionate impact on minority voting and turnout. And as Ari Berman has recently observed, over the past 7 years, 22 states, mostly controlled by Republicans, have passed laws to restrict access to the ballot while disproportionately targeting Democratic constituencies, including people of color. And if you follow the most recent news going on in Georgia, we have thousands of registrations being upheld by the Secretary of State of Georgia, who's also happened to be running to become the state's governor. So the Voting Rights Act of '65 was spectacularly successful in eliminating the barriers to registration and voting for African Americans and other minorities. However, the bipartisan consensus that existed for more than 4 decades has disappeared, and strong resistance has emerged as minorities have sought to cast meaningful votes, leading to the selection of their preferred candidates. Moreover, the future seems uncertain after the Shelby decision, especially with the reintroduction of the post-Reconstruction canard of using fraud prevention, which was also used in the previous century and the century before that. And the now disbanded, President Trump's now disbanded Voter Fraud Commission, and its new mantra, it would become of the voting suppression people, the upholding the integrity of elections, to suppress votes, African Americans, Hispanics, and other Democratic Party constituencies. So maybe that original error of not guaranteeing a natural right to vote leaving it to the states was the error that cannot be corrected.